This will be our second screenshot video for this first 2-week period in civil practice, and I'm going to walk through posting 2, which I have up on the screen. You'll see at the top references made to the material and the textual outline, so you would want to be considering that material in conjunction with this posting and in conjunction with what I'll be talking about. I start out, however, just reminding everybody about the Buffalo Creek disaster. I apologize when I say for the 2-week period 9/4 to 9/18 because we're obviously in a different semester, so you can consider that period to be our first 2-week period for this spring 2021 semester. Bottom line is, make sure you get the book and start reading it. I think for many of you, I hope for all of you, but for many of you, the book, it's a nonfiction book, but it has the appeal of good fiction, which is we want to find out what happens next. We have interest in the characters in the book and how they're dealing with the situation. So please get the book and more about the book later. What I can tell you now is that we will have a quiz that I plan to post this Friday. And when I say this Friday, I'm now talking, dictating on Sunday, January 24th. So it'll be, I believe, like the 29th of January. But the Friday of this week, it's just the beginning. Not any part of the quiz will reference the Buffalo Creek disaster. The next point I bring up on the posting is civil litigation vocabulary, and I noticed that in the textual outline there's a glossary of legal terms, and for our first test, which is not scheduled during the week of 9/28, but is scheduled, is if you look at the formal course outline in February, more of that later, but begin working your way through the civil litigation vocabulary. And again, for now, I can tell you that there will be no questions in the first quiz, which I will be putting up later this week. Getting sort of to the heart of the posting and the material and the textual outline is the topic typical events in a lawsuit. And I referenced the typical events on page 2 of the textual outline, and I notice that steps 2 through 6 will be what we will be talking about in large part for the remainder of the course. What I spent some time talking about in this posting is a topic that I believe a lot of people who haven't had familiarity with lawsuits don't necessarily take into account, and I call that pre-suit considerations. In other words, what are lawyers and paralegals doing possibly in regarding a possible lawsuit before the lawsuit even begins. So working our way through some of these pre-suit considerations, there's first we could identify a screening process. In other words, in the first instance, is there a valid legal claim? I use a dog bite, but as an example, but let me use a vehicular accident as another example. Someone calls our hypothetical law firm here in New York State. They inform us they were in a car accident, they were injured. They want to obtain our legal representation. we're going to screen the case to see if there's a valid legal claim. We're going to be looking at not only the facts of the accident, at least as our client relays them to us, we'll get a hold of some accident reports, but we're also going to be greatly concerned about the injuries that the person sustained, because in New York State, and if you took the intro course from me last semester, we had quite a bit of material about the no-fault insurance law, that there has to be a serious physical injury before one can obtain relief in a lawsuit. So we have this screening process that is going to take place. I would just add that a lawyer, not the paralegal, but the lawyer has, when I say ethical obligation, I'm going to be a little bit more specific and say there's a legal obligation connected with the regulation of a lawyer's conduct to avoid bringing frivolous lawsuits. In other words, lawsuits that aren't based in a good faith assessment of what the law is and what the facts are. I would think that practical matters most of the time would cause a lawyer not to want to do or represent somebody in a frivolous lawsuit. Certainly in a personal injury case, that would be the situation, because the lawyer's fee is going to be a contingent fee, 1/3 of a possible recovery. And if the case is frivolous, 1/3 of zero is zero. So I don't think a lawyer is going to be motivated. There may be other instances, however, where the lawyer is going to have to give deeper consideration if it's not a personal injury case. And I'm going to leave it at that. I'm tempted to talk about some of the litigation that littered the court system after the election, but I'm going to move on. And we can say this: if the lawyer believes, and again, that has to be a good faith belief based on the lawyer's best professional judgment, that the client has a valid legal claim, sometimes that claim can be settled even before a lawsuit starts. In that personal injury case, if our hypothetical law firm is representing the injured party, we would be contacting the other person involved or business involved, informing them of our representation, encouraging them to get their liability insurance carrier involved. Hopefully we would then enter into a dialogue with the liability carrier representative, the claims adjuster so-called, and we may be able to resolve the claim without beginning a lawsuit. So there's those pre-consideration or pre-suit considerations that we, I think, should consider typical events in a lawsuit, where the first event starts before the lawsuit begins. The next question is how long does a lawsuit last? Perhaps not surprisingly, the initial answer is, well, it depends upon the type of a lawsuit. What we're going to be looking at down the line is in New York State, but we can do it right now. There's two different general types of civil lawsuits: actions and special proceedings. And by the way, oftentimes special proceedings are just referred to as proceedings. Our garden variety lawsuits are actions, divorce cases, personal injury cases, breach of contract cases. Proceedings are lawsuits that usually can be resolved quickly because, unlike the ones I just mentioned, these lawsuits usually have only one or two essential questions of fact. Everything in family court, by way of example, is a proceeding, and let's assume it's a proceeding brought to enforce child support payments. Well, pretty simple questions of fact. what was the amount that the respondent, that's the person sued, was supposed to pay, and did they pay it? Another proceeding, landlord and tenant. Let's assume that it's for non-payment of rent. So now the question becomes, really, did the tenant pay the rent or not? Sometimes the proceedings are against a government unit. There might be more complexity, but again, it boils down to just a few essential factual questions. By the way, an Article 78 proceeding is a type of proceeding, and it's a proceeding where the government in New York State is sued for non-monetary relief. And you'll see I have an example where the town government has denied a business the right to develop property, and the developer may claim that that was done arbitrarily. And probably the question of fact is going to be, did the town government act with on the basis of a fact that gave it legal justification to deny the developer the right to develop? Our actions, to get back to them, and let's take the personal injury case, are typically what I call fact intense. There's all kinds of different factual issues in the lawsuit. How did the accident happen? What were the injuries? What are the damages? In other words, what's the prognosis for the injury? What are the lost wages? What might the future medical expenses be? So on and so forth. And so actions generally take a lot longer to resolve than do proceedings. And the legislature has recognized that by having this type of distinction, these two different general types of lawsuits, and quite frankly, some different rules. And we'll talk about them to some extent, the differences between actions and proceedings as we move along. And our last topic in this posting is the legal rules that govern the procedures to be followed. And in New York State, we have our basic procedural set of rules known as the Civil Practice Law and Rules, fortunately modified to its abbreviation CPLR. There's different court acts. For example, there's the Family Court Act. There's different court rules, even more specific than the court acts. And judges have their specific rules. So the litigator and the paralegal working with the litigator has to be mindful of what these rules are, from the most general to the most specific. If we're in federal court, the main source of procedural rules is known as the Federal Rules of Civil Procedure, but there's also specific court rules and specific rules for individual judges that, again, the litigator and paralegal have to take into account. So that will end